And I really thank Monique for having conceived the idea, having found most of the speakers. I will attend myself as much as possible. The idea is very simple. We will have 3 workshops, and then we will be dead. I hope not, but anyway, then there's a cocktail. So we will find the others with coffee break at 3, I believe. And then after the coffee break, we will continue till the cocktail, and then we will enjoy the cocktail till we throw ourselves up, or the next panel at 6:30 throws us out. But I'm going to pass the microphone to Monique. I'm very happy that we have found each other, and I'm very interested in what's going to follow. Thank you.
Thank you very much. Can everybody hear me? Hello? Yeah, that's better. Thank you very much, Paul. So, welcome to the eDiscovery sessions. My name is Monique Altheim, as you heard, and I'm an attorney qualified to practice on both sides of the pond. I currently practice in New York, where I have a boutique firm specializing in eDiscovery, data protection, privacy, and social media. The subject of the first panel is principles of eDiscovery in U.S. litigation. What is eDiscovery? The Sedona Conference, a very influential think tank in the U.S., defines electronic discovery, or eDiscovery, as the process of identifying, preserving, collecting, preparing, reviewing, and producing electronically stored information, or ESI, in the context of a legal process. It is a common law concept, a concept that does not exist in the civil code. So why is it important to talk about eDiscovery in the EU, where the majority of member states follow the civil code? Our first panelist, Chris Dale, will elaborate on this question. Chris is the principal of the eDisclosure Information Project. eDisclosure is what they call eDiscovery in the UK. Chris is an independent eDisclosure consultant with 20 years of experience. He's based in Oxford and travels the world as a highly demanded speaker at international conferences on eDisclosure as well as on discovery issues. He also runs a very popular blog, the eDisclosure Information Project. Chris.
Thanks, Monique. I'm going to try and address in 15 minutes or so questions like why we have discovery in common law jurisdictions, what's common and what's different between them, some of the US elements which drive perceptions, because the general perception is that it's an expensive thing that we'd rather avoid, and I hope to persuade you that there are many elements in it that are worth pursuing. And look at how discovery is being imported into EU jurisdictions by various means, and look at some of the risks attached to that. You'll say, well, electronic discovery is something Americans do. That's your first question. Your second question will be, why do we need an Englishman to tell us about it? That's because I'm fortunate in that I get, as Monique said, to go around the world really to all sorts of common law jurisdictions as well as to Europe to talk about what we do, to find out what happens in one jurisdiction, to plant ideas in another. I'm a member of Senior Master Whitaker's, who's over there, from whom you'll hear later, his working party which drafted the English eDisclosure Practice Direction, and that gives me an interest in what's happening in other jurisdictions, what's good, what's bad, what works and what doesn't work. Those jurisdictions obviously include all those former countries, most of the former countries of the British Empire, so Australia and Canada and Singapore and Hong Kong, all have some variant on the eDiscovery rules. The English invented them, of course, but we're the ones who chose to call ours eDisclosure under the misapprehension that changing the name would somehow improve the process, which alas proved to be false. The general idea is it's an equitable principle, we said in England, that you must put all the facts before the court, that the contemporaneous documents are the only objective record, and that the primary duty falls on a party who is taking part in litigation to come up with, produce all the evidence on their side. Contrast, therefore, with the EU and other civil jurisdictions who have no such concept. The cost is going up and up and up, and that's driving commercial decisions in a way that's not necessarily helpful. It's important to note that litigation discovery is not the only driver for information management, something I'll talk about more in a moment. The volumes keep growing, more and more data. You can see endless statistics of how much more data we're producing each year. We're also seeing more regulatory and similar interventions, again something I'll expand on in a moment. These are the definitions of the problem tree. We're seeing conflicts of various kinds, most obviously data protection and privacy conflicts. We're seeing new data sources, with people bringing their own devices to work, the cloud, social media, and so on, are expanding the range of sources in which the evidence may lie, and therefore expanding the problem that has to be dealt with as an eDiscovery matter. We're seeing technology developing to try and deal with the problem, ever more sophisticated means of approaching the problem that technology has created, and that I think is the subject of a later panel. Cost is the biggest element, of course, and as a side issue, we're finding other players moving into what has historically been the lawyers' area and taking their work away from them, which is introducing new areas of competition. The US, of course, as they do with everything, made discovery much bigger. They've done it with cars, they do it with wars, you name it. America makes it bigger, and discovery is no exception. They litigate more, they're a more open nation than perhaps the rest of us are, they have less attachment to privacy. They take the line, for example, that data belongs to the company, not in any sense to the individual that created it. We're beginning to see that rolling back a little, but that's the broad concept. They have a test of relevance, which is much wider than the test applied certainly in the UK and in most other common law jurisdictions. Any document which may be relevant to the matters at issue is potentially discoverable. Whereas we in the UK have a test which could be summarised as, you don't need to look under every stone. Can justice be done with a narrower scope of discovery or disclosure? We in the UK also have the concept that the loser of litigation pays the costs of it, which tends to focus people's minds rather closely on whether what is being spent is money that is worth spending. The US has battles over requests, for example, which perhaps Amor will be telling us about before you even start. The US rather mocks the UK rules. Somebody said to me once, oh, discovery in the UK, that means I will give you what I feel like giving you. We, on the other hand, see the US route as give me everything you've got that may have any bearing on the litigation. And we're therefore poles apart, really, in how we approach the subject. The US is effectively on its own compared with other common law jurisdictions. It gives opportunity for tactical discovery in a way that is more limited in other jurisdictions. There are sanctions for procedural failures which tend to drive up the volume that are disclosed because of the risk assessment that lawyers make. We're also, as a counter to that, seeing judges taking a more active role. They're the ones who get the blame if it's too expensive. And they have the motive and the right, therefore, to intervene more. The broad message here is be aware that US discovery is seen as unduly burdensome by pretty well everybody else, as well as increasingly within the US. And we'll make you a different view on that, but it's just worth establishing that the view from outside, even within other common law jurisdictions, is not necessarily the same as you get within the US. In those other, in all jurisdictions, we're beginning to see changes. Rules and procedures are being adapted or being discussed, and I have to say the US leads on this in many ways in terms of the discussions that are taking place as to how one can limit the costs and the scope of discovery. The US, England and Wales, Canada, Australia and Singapore have all seen new rules and practice corrections in the last 3 years or so, designed to reduce the costs, reduce the time taken. In the UK, we're seeing cost management growing as an idea, as a means of limiting the impact of a discovery and disclosure exercise. And we're seeing a growing emphasis on cooperation and competence expressly. A new rule, a new model order in the Southern District of New York, for example, now requires lawyers to say, to expressly certify that they are competent to understand what their clients' sources of data are, which is a massive step forward in terms of limiting the overall exercise. We're seeing judges focusing on technology and understanding what technology can do, and we're also seeing judges inquiring into document retention policies and other methods within companies for controlling their data. Not very long ago, it has been seen as unthinkable that a judge would be concerned with the back history, as it were, of the data. That is changing. Within companies, and partly as a reaction to that, but partly because of the pure expense, we're finding a new focus on information governance. That is, we're seeing senior people appointed within companies to oversee the whole information management, how the data is kept, how it's deleted, what it's used for, and how it turns up in discovery. One survey last year found a growing number of people senior people within companies with the label eDiscovery or something similar to it in their job title. So it's beginning to permeate, not just in the US but elsewhere. Where are those skills going to come from? They're going to come largely from eDiscovery people who have developed the skills and ideas for limiting the problem. And that will include, I think, a new focus on defensible deletion of documents. I mentioned earlier that we're seeing there are a number of collisions built into the whole system, all the systems in all these countries. We see a tension, obviously, between time and cost and volume and accuracy. All those things pull in different directions when we come to look at discovery. We're seeing tensions such as companies beginning to realise that they needn't necessarily spend money all their money with lawyers, but they can do an increasing amount of this work in-house. In the UK, we're seeing competition from other whole jurisdictions, with Dubai and Singapore singled out as places that are taking work away from, potentially going to take contentious work away from the UK, and that's driving a better approach to management of the problem. The biggest issue, perhaps, though, is the US commercial empire bumping into jurisdictions with no discovery tradition, which obviously includes the EU countries, with the US desire for completeness conflicting with privacy and data protection. Europe, however, is now having to face up to this, to the management of electronic documents, partly because of the US demands for broad discovery, with companies saying, we must, that our court requires us to collect these documents. Partly because of growing EU regulatory and other regulatory interventions. 5 years ago, if you asked an EU company what the biggest driver was, they would have said it was the US Federal Rules of Civil Procedure work. That, I think, has now changed, and regulators and various authorities, principally US authorities, who seem to think that our business is their business, are increasing the pressure on EU companies. In addition to all that, there's the growing realization within companies that pure business efficiency requires them to manage their documents better than they have been. I'm not going to trespass on the cross-border issues that are coming up in a later panel. Safe to say this, that each side finds the other's position literally incomprehensible. EU lawyers simply cannot get their mind around the US demands for very broad discovery, and many US lawyers and courts indeed simply can't understand the idea that a supervening law should stand in the way of a discovery exercise. That, I think, is changing, and perhaps Amor is going to cover that in the later panel. There's a growing realization, not that either side is necessarily right or wrong, but that we have to find a compromise between privacy and data protection on the one hand and the demands of US courts on the other. How we're going to arrive at that, I don't know. We're certainly not going to find it in the latest draft of the new regulation. That's driven in part, I think, by US lawyers being, in the view of many of us, overscared of their own rules. They should be increasingly willing, I think, to consider defensible ways of deletion and thus reduce the whole problem the exercise of identifying personal data diminishes if the whole volume of data has gone down. And that's being advocated by many people, even within the US, never mind outside it, as a means of containing the problem. It has to be said on the other side that those foreign companies, EU companies or whatever, who wish to trade in the US and have access to US courts, can't play by their own rules. You can't just turn up in an American court, particularly as a plaintiff, and say, you must play by your set of rules, but I have a special sort of magic cloak called data protection and privacy, which means that I play by a different set of rules. And that highlights the need for a compromise between these two positions. More and more companies in the EU have sister companies, have parent companies, have subsidiaries, have other connections with the US, which have to have factored into them the differences between these jurisdictions. It's not just the US. The UK Bribery Act, which came into force last year, purports to have control over any company with any connection at all with the US, with the UK, I'm sorry. And that is having a significant impact in the EU. I've been to whole conferences, whole sessions over here, particularly in France, devoted to the potential impact of the UK Bribery Act, a whole new piece of legislation, which has, as one of its defences of not preventing bribery, has something called adequate procedures as a defence. If you have adequate procedures to prevent bribery, then that operates as a defence. The management of information is obviously only one of those procedures, but it's an important one. There is a crossover, therefore, between the Bribery Act and all these other things. In summary, you would rather know, certainly when you're looking at Bribery Act prosecutions, you'd rather know what the scale of your problem is before a prosecutor finds out, before it's unearthed on discovery. And all that is driving a new look at information governance, at the whole control of one's own documents in anticipation of discovery. And that, I think, is a lesson that's as valuable in the EU as it is in the US and in other common law countries.
Thank you, Chris, for such a wonderful introduction into the world of eDiscovery. Now to our next subtopic. eDiscovery practitioners in the US talk routinely about the duty to preserve, litigation holds, and spoliation. But for most practitioners in the civil code member states of the EU, these words do not mean much. Amor Esteban, to my left, is going to give you an eDiscovery 101 and introduce you to all the basic principles in 15 minutes. Amor is a partner in the law firm of Shook, Hardy & Bacon and is based in San Francisco. He has 22 years experience in complex litigation with particular emphasis in electronic discovery and data management. Amor is also the chairperson for the Sedona Conference Working Group 6 on International Electronic Information. This working group has just published a draft on international principles on discovery, disclosure, and data protection, which you will find in your materials. Amor.
Thank you, Monique. So as I understand it, I have 15 minutes to teach what usually takes about a semester in law school. I appreciate that. I also want to make mention of my colleague, Jim Daly, who's here, who previously had the seat that I have now as the chair of the working group 6 of the Sedona Conference. And what we focus on is the interplay, if you will, between U.S. discovery and data protection laws. And our primary focus, at least the last several years, has been the data protection laws of the EU, namely the Data Protection Directive. And we do have just published in December of 2011 our international principles, which are available here today. They're also available for free download at thesedonaconference.net. So if you go there, you can receive that. And let me tell you a little bit about why we put these principles together and what they're intended to do. I think I have to go back a little bit further than even that. In around 2001, 2000, somewhere in that time frame, a number of us were practicing in this area, including Jim Daly, saw that there was a proliferation of discovery related to electronic data, and yet there were no rules available to explain how it was done in conjunction with what the existing rules were. And there was a lot of very differing opinions by various courts where parties were being sanctioned for violation of the discovery rules, for violation of the preservation obligation, which I'll discuss in a minute. And there was just literally confusion. Parties did not know what they had to do, what was their legal obligation, because we were operating in a digital world and trying to apply laws that were created, many years before. So a number of us got together and started talking about the fact that there needed to be some guidance in this area. And from that, the Sedona Conference was born. And Richard Brayman, who is the director of the Sedona Conference, it was sort of his brainchild. I know Jim Daly was involved as well. And ultimately, we published, and I believe it was 2002, the general principles which enlightened courts as to what the best practices were in the electronic discovery world relative to the sort of sporadic and inconsistent decisions that were out there. That eventually, I think, is fair to say, was used as the basis for an amendment to the Federal Rules of Civil Procedure in 2006, which became generally known as the eDiscovery Amendments to the Federal Rules. And that is what we're currently operating under. Now, one thing I should note is, like any good American, we're never satisfied with anything that we do. And so there is now an effort again to amend the rules, this time to put some stronger parameters, more definite walls around the preservation obligation. And that is an ongoing effort right now by a number of people, a number of in-house corporate people are behind that, as well as a number of academicians. And we believe that we will probably see some additional changes. And even if those changes don't come to the federal rules in the form of official changes, what we have seen is a dramatic change by the judges who are now enlightened by what is going on in the United States with regard to understanding the preservation obligation, how much it's costing companies to try to preserve documents, and why there's a need for change. So I think it's fair to say that even if we don't see official rule changes, you are definitely seeing a change in the atmosphere. You're seeing a change in the way the judges view these issues. So with that as a background, let me start with picking up on a few things that Chris said. Our discovery atmosphere is much different than that of the folks in the UK and certainly the rest of the European Union. And primarily it's because of a concept that was born in around 1938 when the discovery rules were first enacted in the Federal Rules of Civil Procedure. And the theory was at that time that if you have all the information that you need before you go to trial, that would be the most likely avenue to receive a just and speedy trial. And so the concept of discovery was, rather than wait to trial to find out what the other side has and then possibly get sandbagged, to learn ahead of time what the other side has. And not only does that avoid a situation of being ambushed at trial, which is the way that trials used to be had, but it also gave you the advantage of knowing the strength and weaknesses of your case as well as the strength and weaknesses of the other side's case. And that ultimately would lead to settlements. In fact, it did. There's been a huge decrease in the number of cases actually tried in the United States, largely due to the fact that the parties, by the time they get to trial, which is generally about 2 years from the date that the complaint's filed, the parties already know what the strengths and weaknesses of the case are. And so, and there's a lot of science behind this. There's a lot of experts that will come in and work with you if you need that kind of help. But you can put a value on the case. And of course, the other aspect of this is that the cases in the United States have gotten much bigger, largely due to mechanisms that allow the aggregation of claims, such as class actions, MDLs, multi-district litigations, and things of that nature. So now you're finding the plaintiff's counsel, rather than bringing one case at a time and having to suffer the expenses of one case at a time, can aggregate a number of claims all at the same time, bring them all, and that gives them, the plaintiff's counsel, much more leverage in terms of the amount of discovery they can afford to do, and in turn, what the value of that case is going to be. So knowing what the value of the case is, knowing what the other side has, having the efficiencies, if you will, of the discovery process, it puts the parties in a position where it leads to early settlements. And when I say early, I mean before trial. I'm not saying that the case is sold the first day, because they don't. But it does give the parties an opportunity to evaluate the claims and put a dollar value on it, and as I said, that leads to settlements. The difficulty with what has become eDiscovery is that in the old days, particularly the defendant had the resources, the defendant usually had most of the evidence, and the other side didn't have a lot of money, and it wasn't worth their time to spend a lot of effort in doing discovery, and so discovery was much more limited. In fact, one of the abuses that the plaintiff's bar used to complain about all the time was they would make a request for information which should have produced maybe 20 documents, and the defendants would dump hundreds, if not hundreds of thousands of documents on them to bury the information. Now the tables have turned, and the advantage, at least in today's litigation atmosphere, is on the plaintiff's side, because the defendants do have the documents, and the plaintiffs have the mechanism to ask for those documents and data through the discovery process. And what that means is that discovery can now be used on the other side of the table. So a plaintiff's lawyer can make the litigation extremely expensive, consistently asking for more and more information, making very broad discovery demands, claiming that they need information from all sorts of various sources. And it's not unusual, you can ask anyone who's been involved in U.S. litigation, for the sort of interrogatories or the sort of requests for document demands that start with, please give me any and all documents that you have related to this particular issue. Which, of course, any and all in this day and age, with the advent of computers and technology, is a lot of information. Any one product now literally has billions of individual pages of information. Everything from emails to planning documents, to marketing material, to regulatory information. Now, I practice a lot representing pharmaceutical companies and other manufacturers, particularly in mass torts and class actions. And I can tell you from personal experience that any a set of document demands about a particular product, say a pharmaceutical drug, would literally fill this room if you put every single piece of information on paper. And yet the plaintiffs will insist on filling this room to get the information. Why do they do that? Do they really review that information? No, they don't. The real reason is to make the process terribly expensive for the other side. Then the other side is more likely to want to settle the case, and that's what it boils down to. And that's where the arguments now are in terms of discovery abuses and abuses of the preservation process. The manufacturers tend to claim that the other side doesn't really need this much information, and the other side says the information is buried in the details, delves in the details, and we need to look at all the details to understand what's really happened here. And there lies the rub. Preservation is somewhat of a unique animal. It's always been around, but it's never been as big of a deal as it is now. And I think we need to understand preservation to understand why there is such a challenge between U.S. discovery and EU data privacy. Preservation is the rule that says at the time that you know of litigation or reasonably anticipate litigation in the U.S., you have an obligation to maintain the documents and any other data that are relevant to the claims and defenses in that case. Now, what is relevant to the case is unknown because we haven't litigated the case yet. So you're under an obligation to presume, to make an intelligent determination of what may be the data that will be relevant in litigation. And remember, it's not just litigation that is actually filed, it's litigation that you will reasonably anticipate. And it's not only the civil litigation, but it includes criminal investigations and government investigations. So if you have done something, if the company has done something and undertaken some sort of action, and there is concern that the U.S. government may come in and investigate them, that under the current standard, and certainly the way a number of courts will interpret it, triggers their obligation to read and preserve the documents. And since we don't know what's relevant, the knee-jerk reaction is to save everything. And by saving, I mean you can't destroy it, you can't manipulate it, you can't change it, you're supposed to maintain that information. Now when you put that in the context of today's information systems, you're talking about maintaining information that's kept in thousands of different locations, including the very scary concept of having to go to backup tapes and that sort of thing. So the amount of data that is at issue is tremendously huge. The opportunity to make a misstep and have the data deleted either automatically by an innocuous part of your information system that just sweeps data every once in a while, which is very common, for example, in email systems, puts the defendant in a position where not only do they face the litigation and the damage potential related to the merits of the case, but now they have this whole other concern, which is if documents are destroyed, if data is destroyed, and a judge later determines that it should have been maintained, then it puts them in a position of a possible spoliation claim, which can bring civil sanctions. And in fact, particularly in a government investigation of a criminal case, can bring criminal sanctions. I mean, I'm sure many of you remember when Arthur Anderson was criminally prosecuted for the destruction of documents related to the Enron litigation. That's an example of a government investigation where the folks are criminally prosecuted. So how does that all come into play? Well, particularly with the advent of the 2006 amendments to the Federal Code of Civil Procedure, what happened is a lot of companies became awake to the concerns of discovery and spoliation in electronic information systems. And they realized, sort of through case law, but also through a lot of practitioners and a lot of vendors in this space, that there's a lot of data that U.S. companies have in their affiliates in the EU and in other countries. And it's not just U.S. corporations, but there are also non-U.S. corporations who have affiliates in the United States. And there is also the possibility of third-party subpoenas, which I won't go into at all. But the bottom line is that if there is U.S. litigation and it involves a corporation here in the EU, and the litigants in the U.S. are deemed to be in control of that data, then the U.S. courts can oblige those companies to produce that data. Now, one asks, and this gets us to the Hague Convention, which Master Whitaker, I think, was going to be addressing a little bit later. One asks, can you get that information using the Hague Convention? Well, the courts, the United States Supreme Court, in a case called Aerospatiale, took the position that while the Hague Convention is a potential avenue, the district courts are not obligated to use it. And instead, the district courts are to undertake a balancing test and make a determination of whether the EU policy concerns are more important than the U.S. Policy concerns, and then decide whether the data protection law should supersede the U.S. discovery rules or the other way around. And for those naysayers like Chris in the audience, there are several examples of U.S. court judges who have considered the issue, applied the Aerospatiale case, and have concluded that the EU data protection scheme is more important in that particular case and should be upheld. And if anybody wants those cases, they can come and see me. I've got them, and they're also in the paper here. So the bottom line is that is where the Sedona Conference has decided to step in, which is Working Group 6 on the International Principles, and that is the conflict that's possible or that is potentially in existence at the time that U.S. discovery needs encompass information that's protected by a non-U.S. country's data protection laws, and in particular, particularly with this paper, in particular the Data Protection Directive and personal data as it relates to discovery. So that's where this paper comes in, and I don't know that we want to go into the paper now.
No, Chris, I have a question for you, just for the benefit of the audience who is not about the sanctions that the courts impose in cases of spoliation.
Yes, I'm here, Chris.
Yes.
Oh, yeah, the sanctions are wide-ranging. They can be as minimal as paying attorney's fees, and that often happens if documents were produced originally and now the court says no, you have to produce them. So a lot of times the sanction will be you have to pay the other side's attorney's fees and have to bring the motion and whatever else they had to do in terms of getting those documents. So that's sort of the low end of the totem pole. On the other side, and I'm not, other than criminal prosecution, which I already discussed as a possibility, on the other side of civil sanctions is the court can enter default judgment against a party that is not compliant or the judge believes has not preserved appropriately or complied with the court's order. And in a default judgment, that basically means you're out. Whether you're the plaintiff or the defendant, the judge just entered a judgment against you. Probably the next worst sanction, the one that we started seeing used a lot quite a bit until a couple of recent cases, including one by Judge Shindlin, Pension Committee, and another case, Camerata. What we used to see a lot of, and I'm not saying it's still not there, but I haven't seen it as much since those cases came out, is a adverse inference instruction. So this is an instruction to the jury that you are entitled to take into consideration this bad conduct of this party in not producing the documents or in trying to hide the documents or in destroying the documents. And you can take that conduct into consideration and it may influence you that whatever they did is inappropriate and therefore there's a likelihood that everything they've done is inappropriate or worse to that effect.
Okay, thank you very much, Amor. And now that we know everything about eDiscovery, we need to find out how to implement those rules in practice. So I can't think of anyone more qualified to talk about the practice of eDiscovery than George Altheim. George is a seasoned veteran of the legal technology and services industry. He's the founder and CEO of Integrated Legal Technology, a legal technology consultancy. George is also a founding member of the eDiscovery Training Academy and Advanced eDiscovery Institute at Georgetown Law Center, where he teaches on a variety of topics. For his work in the legal support area, Mr. Rudo was named the Champion of Technology by Law Technology News, as well as the Tech Star and globally recognized by the United Kingdom City Tech Magazine Global Tech Leaders Top 100. George.
Thanks very much. I once again have a topic that I need to cover in a very short period of time, which usually takes a lot longer to cover, much longer to implement actually. I have the pleasure of working with attorneys as a technologist, so don't hold it against me. This can easily get frustrating, so what I'm going to try to do is to cover really basics, and if it's more elementary to you, I apologize that it's very basic, and if you have questions about more sophisticated side of the practical aspects, I'll be happy to cover it later. The bottom line is, and I don't mean to oversimplify, but to implement the eDiscovery project, or any discovery project, is an ability to respond to a document request and review documents for responsiveness and privilege, among other things, before turning it over. Obviously, when the document request is served, attorney representing a particular company is not going to advise to just blindly turn over all the documents. So the process is, how do we make that information available for a group of attorneys to review for responsiveness, confidentiality, and for privilege? Back in the days, Amor, I think mentioned, the process was more linear, even though probably more voluminous, because you have to deal with paper. So you have to often go through the exercise of going through the boxes of paper, identifying particular documents that need to be responsive, creating all kinds of logs to do that. And when eDiscovery first arrived at the scene, the first attempts to deal with electronic documents were just no less than print them back to paper. It was a very interesting time where I think a lot of providers in eDiscovery space made a lot of money because what they did, they printed electronic documents to paper and they scanned them back into databases so the lawyers could review them, and then they printed it again because they needed to produce them in paper. So that golden age was quite golden for them, but not as much for all of us who had to support it. It was a very, very difficult process. When eventually people started realizing that this is not a practical way of dealing with this, and then on top of it realizing that there is a lot missing when you start printing electronic documents, an issue of metadata, which was widely discussed as information that you don't really see when you print it, but it's associated with a document in electronic format. The discovery started moving to eDiscovery. However, the process itself remained linear. Somehow, I don't know how that happened, but it seems that lawyers are not very open to change, so the process remained the same. The documents were processed instead of printed, but the process of reviewing documents for responsiveness and identifying production sets remained the same. It's basically you go out there, you grab everything you could grab as much as possible, then you convert all those documents into the universal format, and there were major challenges in what to do with certain formats of documents that are not easy to convert. And then there would be an army of attorneys sitting in front of the screens going from document to document to document, no joke, really, that way, identifying what's responsive, what's privileged, what's confidential. We made quite advancements in the past, I would say 5, 6, 7 years, and developed the practical aspects in more leaps and bounds than ever before. So to address them, I'd like to come back to the beginning of the process, and it was a conversation in regards to preservation and the information governance that both Chris and Moore touched on. Really to deal with the large sets of data, and I think it's important to note that electronic data volumes don't stand still. The cheaper the equipment is, the more adjusted people are to electronic communications and creating documents in different formats, the more sources of information are opening up, data on the cloud, social networking, you name it, the more documents are being created. So we're now dealing with the phenomenon that are not just how to deal with documents in electronic formats, but really the volume itself has become quite an issue, quite a problem. As a result, there is a lot of emphasis that is now put on what do you do to properly identify the sources of information in the regular course of business. So the electronic records management, data management, information governance models are something that's quite on people's mind these days as the companies started to think proactively about what would happen if the litigation hits me and the document request hits me. What will it take, how long it's going to take, how much it's going to cost me to actually get all this information in the format that can be reviewed by the attorneys. So more and more companies are now implementing various aspects of their information governance and their data management to assure that they at least know what the data is, because that's quite an exercise as well. I mean, we think about data in the sense of how it moves from one place to the other, but also especially multinational companies really have data all over the place. And if you take into consideration all the mobile devices, handheld devices, and so on and so forth, it's very difficult to keep track of where the data is and what's relevant and what's not. So as a result of that, the companies are relying on a group of consultants and other specialists in the field that really help them identify what their process is, what their document retention is, how it impacts the scope of data. So I'm going to go back and forth between the old and the new to give you an appreciation of what's been changing. So as we said, in the old days, when the time came to actually collect the data, it was a very linear, straightforward process. You know, data was just copied over and handed over to a provider in the space that would convert it in a universal format and create a database that would name the source of data. The success of such exercise varied. So what is collected? Emails, documents, as I mentioned, data on social media, data on the cloud, handheld devices, voicemail. The most difficult collection target, in my opinion, are still proprietary or complex databases. Those are the databases that are not designed to export documents, especially when they're relational or hierarchical in nature. When you deal with a lot of tables that are just relational to each other, it's not that easy to get the documents out. So I think it's important that at the point of collection itself, the forensic specialists are available to assist with such data. There's still a debate whether you need a forensic specialist all the time or not. From my perspective, I think it's more the case that you do than you don't, only because that if you make a mistake or you're not sure about how certain data translates as far as the collection and transfer of data, there's someone there that at least understands what the data is and can testify to it later. So it's a very common practice to have somebody who's able to testify to our actual process and the in the data itself. The other, not so recent, but I think a revolutionary approach that hit eDiscovery practical aspect is the fact that you don't really need to collect everything in order to have everything. So obviously, preservation is dealt with and all the documents are properly held, but at the time that the actual documents need to be collected, to be processed, and to be reviewed, a notion of early case assessment, or as I like to call it, early data assessment, there's still a debate about how to call it properly, is been quite logical. And the approach is you really would like to know as much as possible what kind of data you're collecting while you're collecting it. So it's an idea to give you at least the scope of data and understanding what's more relevant than the other, and give you an opportunity to select the data that's the most relevant in the beginning and start the review right away. So it is in the process of review, we start identifying that the scope is incorrect and we need to go sort of back out and look at it in a different way and zoom in on different data if this can be accomplished. So there are quite a few tools that are available out there, some of them actually offering this early case, early data assessment functionality during collection. The others are offering it post-collection, and after you preserve all the data, you send it through a particular software that gives you a map of data, identifies where the data is. The other driver for it obviously is cost, because back in the old days, imagine grabbing all the data and processing all of it. The prices for processing are quite high, even though they've been dropping, but we're dealing with this paradigm when the prices per unit drop, but the volume of data continues to grow. So it's still a pretty expensive exercise to go out there and grab all the data and process it and convert it. So there is a lot of creativity that's now being built into eDiscovery, as I think it should be, of implementing various search engines and ability to assess the data and identify the data early on in the process. So again, in the old days, after all the documents are collected and processed into a database, it was a linear process of reviewing documents. Now the data assessment is happening during the review as well. There is quite a few of searching and filtering that's applied against it, and subgroups of documents are being created and marked in bulk. There's a lot of search engine kind of philosophies applied to it, when the accelerated review aspect gives you a proportional, more statistical way of identifying groups of documents in the same category. There's still a debate going on about what's accepted in the courts of law and what's not, but at the very least there is a very clear effort towards moving away from the linear review and focusing more on the speed factor and also on the cost factor. The review platforms themselves got a lot more sophisticated than they were in the past. The days of the flat databases like concordance and summation are pretty much over. The clients are now expecting more sophisticated databases that enable you to do lots of different things during the document review itself. Again, an important piece to it that you are now able to review some of those documents in native and not deal with all the aspects of conversion from an image to a native and back. 2 words on international, because this is an international conference. There's lots of logistical issues when you deal with the international project, obviously for the reasons that have been described before. The more challenging part is how do you move data from one place to the other, and how do you really build a unified centralized database where everyone can go to and review documents and search the documents. If you really can't put it together because there is some restrictions for data migration, it's very difficult to do so. We actually experienced a very interesting paradigm where we always worry about how to take data from the more stringent privacy laws into less stringent. But then you think about it in reverse and you say, okay, great, so I'm going to place my database in the most restricted area so there'll be no issues with documents going there. The problem is, of course, if you take the documents from the non-compliant territory into compliant territory, those that originally were not subject to privacy and compliance now become so. The other issue with international is the fact that documents are in different languages, and there's a growing number of documents in eDiscovery scope that are not only in a particular language, but in dual or triple languages. And it creates a bit of a challenge there, because how do you then process a document? How do you populate metadata part of a database? What language do you use? There's an issue of Unicode that's been raised and discussed at nauseam, I think, in the US, because most of the US systems were operating on the ASCII, which is a table of characters that are specific only to Latin characters. But when you take the eDiscovery globally and you deal with other alphabets, how do you make sure that it's properly processed? So when you search the documents, the indexes that are built in the search engine can find the document that you're looking for. And of course, there's also an issue of documents that are actually in different languages that can be recognized as such. Not everyone speaks all the languages in the world. I mean, in the States, it's still a bit of a challenge to speak more than one language. We won't go there. But it's virtually impossible to create a team of attorneys that would speak potentially all the languages that are represented in a collection. So there's quite a creativity that happens there, because you really don't want to take all the documents that are not in languages that the people in the group speak and translate them. It's expensive. So there's a combination of solutions that are available. First of all, the databases themselves are now able to recognize the language. It's a major step. So you can sort the documents at the very least by the language. You can identify which documents can be reviewed based on the language, which cannot. And then from there, you can rely on a machine language translation that's not going to give you a kind of translation that you want to produce or attach to a document, but at least will give you an idea what the document is about, so you can identify the scope of documents that might be more relevant than the others, select those documents, and then apply human translation in the effort to really understand what's in the document. The last part of it is the fact that the documents still need to be produced and exchanged, and there's a whole discussion that I think has already been referenced as a fact is what's appropriate, what's applicable, the whole idea of a meet and confirm and recognizing what the scope of the data will be and how the exchange will happen. I think that applies specifically to the volume of data and relevancy of the documents that have been exchanged and how to get it recognized. Finally, I think it's an important paradigm that's changing right now from the perspective of practicality. In the old days in the US, all the decisions around practical aspects of eDiscovery were made by law firms. Corporations pretty much were just dealing with that. We're in charge of choosing the approach, choosing the technology, choosing the providers, and so on and so forth. Now it's changing, and it's changing pretty quickly. Now the corporations themselves are much more aware of the issues, and they're aware of the costs, more importantly. So they like to make decisions, while law firms still participate in that, there's also a third part of that triangle that, as I mentioned before, the various consultants that are operating in the space that help to make that decision, being a bit of an independent view between the law firms and the corporations. So those are the basics. I think I'm out of time. There's much more to it.
There are 5 minutes left for question and answer. Thank you very much, George. If there are any questions, we have 5 minutes for answers.
I have a question for George.
What should I do?
on the translation, the identification of a foreign language and then the translation and use for purposes of preliminary review. Are you finding challenges with what I'll call untraditional languages like Chinese, where you're dealing with
non-ASCII?
Right.
It's moving along quite nicely, actually. It's good to see out there that people are really starting to think global in that aspect, and the code itself that identifies the language really depends on the sophistication of the language itself. It's really not that complex as far as how the code is built, but if you have a language that is very specific, either with specific characters or a combination of words or characters, it's identified as such. In most of the cases, general groups of languages are identified easier. In other words, Chinese is identified easy these days, Japanese, and so on and so forth. They might be a bit of a challenge when you want to, recognize Ukrainian and Russian. in the same set, because those are very, very close languages, using the same alphabet and using a lot of the same grammar behind it, or say Bulgarian and Russian, or say Czech and Slovakian. So those are the shades that are a lot more difficult to identify. But I think once the groupings are done properly, chances are that people that will focus on that group of document will identify within a very short period of time that there's in fact document written in Ukrainian and Russian. But it's moving along quite nicely. I mean, we're only talking 5 years ago when this, aspect of recognizing the language was just laughable. It wasn't even available.
I'll add that we're seeing a lot more complication in documents that we receive. For example, you may have in one set of documents, sometimes in the very same document, you may have English, Chinese, and Japanese, or Russian or something. And so being in a position where you can first identify that you have those language issues with one document is a huge leap if you can do that. And second of all, then getting the proper review team to be able to review that and tell you whether it's relevant or not to the litigation is huge.
Yes, I do have to point out that in our third session that starts at 5:30, we have a very well-renowned specialist, Dr. Evans, who is world-renowned in this issue of languages. So this concludes, thank you, this concludes our first panel. Thank you, Chris, Amar, and George. And we'll have a half-hour break, and at 3:30, we will have a panel on cross-border eDiscovery and the issues that it brings along with data protection.